just, I believe, continue the amazing bar that we have in the Seventh Circuit, which is really, really a special one now that I've especially been all throughout the state. The Seventh Circuit is really a special one.
What qualities do you think are important in a circuit?
I think common sense. I think, I believe respect, respect of time, respect of people's opinions and words, courage to make a determination and make a ruling and stick to it, legal acumen, knowledge of the law, patience. I believe all of those are important to be a good judge.
All right, you have a background in civil, family, and criminal. Where do you think you would be best suited to serve on the bench?
I know the answer really that I feel is anywhere. I come in and I don't have really any issues with any conflicts or anything like that. So I can come in and I can take the bench in all of those areas. I think probably with the juvenile, there's some crossover with some delinquency and dependency too. So that expands my abilities there. I believe that I would be best suited where I'm needed in the circuit because even if it's an area that I haven't practiced, I'm willing to come in, do the job, get the information, learn, and do the best that I absolutely can.
Ms. Clifton?
Yes, ma'am.
So you've been in Palm Beach since 2018?
Yes, ma'am.
Okay. So why not apply for a position in Palm Beach?
When I left, it was never going to be long term. The plan was always to come back into the Seventh Circuit. And so initially it was supposed to be approximately 3 to 5 years that I was going to be gone. And so for those reasons, I didn't jump into a big law career there. Anybody that's left practicing law, it's hard to transition out of a law firm and something, and start new. But then I was blessed with a pregnancy. And so that was something that the decision was made because it's a high-risk pregnancy that I was going to step back. And my husband has a great job there. He has great insurance and stuff. It made sense for our family at the time. But never, ever were we... I always say I live with one foot out the door because my goal was always to be back here. Our goal, it's not just me, it's our, I believe becoming a judge is a way of life for the whole family. And so it was always our goal to get back here.
Tell us about any professional contacts, organizations that you've been in the Seventh Circuit since you left in 2018.
Well, I've maintained the Volusia Bar membership. I did that for the last several years. All right, so when COVID happened, I started getting calls for the Seventh Circuit, actually. Hey, can you handle my divorce case now because everything's virtual? And I'm like, actually, I can, And it was a good transition back from being home with my son and spending the majority of time there into actually practicing law again. So I started doing virtual cases in front of Joan Anthony. I did a family law case. So I started doing cases in the Seventh Circuit because I was able to. It wasn't costly to my client. And so then, so I established the Jacquelyn Clifton, J.R. Clifton, PA at that point for that purpose. So that was all remote. I worked at Compass Law Firm for a little while as a family law attorney while maintaining the J.R. Clifton, PA. The thought behind that was that I was going to maybe open offices in Volusia County for them because they knew my goal was to come back here. And then because Orlando, they're out of really Orlando area and stuff, they started having in-person hearings and stuff again, which, kind of defeated the purpose of the virtual practice. So then I became of counsel for Halifax Law Group, and I did that again remotely, which is in Volusia County. So I maintained that for a series of time, again, as a 1099 under J.R. Clifton, PA. And so I still refer out cases. I have a case. I just had a hearing in person in front of Judge Jolly on November 4th in Volusia County. That's the only current Volusia County case that I have. So most of the time I would still be called because I still maintained connections and not only in Volusia County, but St. John's and Putnam and Flagler as well throughout the circuit.
Tell us about any professional memberships that you.
Only the Volusia County Bar Association.
You were the president in 2012, 2013?
Of the Women's Association.
Oh, okay.
I was for them. I'm sorry, I thought you meant since I left. So before leaving, yes, I was on the board of Volusia County, Volusia Flagler Women's Association, and then I was a board member, and then I worked my way up to be president there. And I was also on the board of Volusia County Bar Association before I moved.
And anything since you moved?
Just the Volusia County Bar Association. In Volusia County, I am on the land use and planning on our local government where I currently.
Ms. Clifton, talk to me a little bit about the type of civil work you're doing right now.
Sure. So essentially when a company is sued or a business is sued, they call their insurance company and they say, hey, we've been sued. And they say, okay, and the insurance company retains us to represent the business. Sometimes, they're usually construction sites, construction companies. So it could be a trip and fall on a sidewalk, and we represent the sidewalk company, or maybe a sub of the sidewalk company or a roof leak. So it's a lot of motion practice, and it's a lot of dealing with corporate representatives and things like that.
How do you think that civil experience has helped prepare you for being a judge?
I think that, to be frank, there's a lot of attorneys that I come across that don't have a great grasp of the evidence code, and so I think probably, you always practice with integrity. That's very important to maintain a certain level. Certainly for me as a litigator and hopefully a judge, I always want the reputation of that I did things the right way, ethically. And so I think that probably not advocating for my client, not as a judge, but doing the right thing still, making sure that when I'm presenting something to the court, I know that I'm utilizing the actual rules and I'm utilizing the evidence that is admissible and things that I'm going to be able to use to bolster my case. So I think that helps me recognize that you have to have patience and step back and recognize that there's different strengths and weaknesses in other attorneys and in different areas. I think part of that plays in with other practices with the emotional component of certain types of law is different for, say, family law cases than it is for what I'm practicing now. So I think that helps with the temperament and knowing that you have to deal with, quite frankly, some people are like, I don't care, it's my insurance, you just deal with it, do whatever. Whereas the family law case or the criminal cases, the homicide next of kin, they're more involved and emotional. So I think probably all of that has led me to the ability to say, hey, every case is unique, every person's unique. You can't just blanketly handle everybody the same way. You have to be able to sit back and deal with this particular case, this particular set of facts, this particular person timely, efficiently, and using the laws that are on the books.
Why do you think there's so much motion practice in construction? That's what you referenced. Why is that? Is it perfunctory or is it real? I mean, should it really be in front of the court? How should the judges deal with those types of motions? Mm-hmm.
It's an interesting question, and I think that there's probably many layers to it. But to be succinct, I'm loath to go before a court with a discovery or scheduling issue. I don't want to be one of those attorneys that bottlenecks the court. Unfortunately, sometimes you just really have to because you can't get somewhere. Like, for instance, right now we're running out of time on a mediation, and there's 6 different. Did I strike it out? There's 6 different attorneys in this case, and so nobody's available when this person is, and nobody's running up on a deadline, you know? So in that case, that's a situation where I have to do the motion to compel mediation dates and stuff. Because for some of the people involved, the benefit is delaying the conclusion of the case, right? That benefits somebody more than others. So playing kind of games with the calendar sometimes is the goal of somebody. So sometimes I think that it's necessary. You do have to get it in front of the court. But I think it should be few and far between. I think that motion practice in the civil realm, I think, helps resolve cases. I think that if maybe you have, from my perspective, if you have a plaintiff that sees that you're actually, as a defense, working the case and finding the weaknesses and exploiting those, then that motivates them to settle. I have had great success in mediated settlements and in settling cases since I've been there. So I think sometimes it is necessary, and it does help move cases forward to resolution when you have someone actively pursuing a defense, a valid defense.
Ms. Clifton, what do you do in those cases if you're the judge and you've got parties that you can kind of tell are purposefully delaying, whether it be setting mediation, depositions, whatever it be? How would you handle it?
Well, I think the legislature is about to handle it for us starting in 2025 with all the rule changes. But I think what I found very effective is the requirement for the meet and confer, at least the telephone conference meet and confer, not just the emails back and forth. I find that to be very effective because it is true. Once you have a conversation with somebody, and Mr. Maidock, to your question earlier, communication, I believe, is critical for a judge. When you have communication and you express ideas and you exchange positions, you can resolve a lot of things, you know, so you really do knock that off. But to answer your question directly, as a judge, what do? If all else fails, you have to hold someone's feet to the fire. You can do it respectfully, you can do it civilly, but you put deadlines. You know, I know that the sanctions should be the last resort, and certainly punishing the client for antics of the attorney should be the last resort. And I mean by striking pleadings and things like that, that's such a drastic measure. But I think that I had a judge that told an attorney that, look, if you don't do this, if you don't get this done, you're losing privileges of virtual appearances in my courtroom. You're going to have to start coming down. You know, if you don't have time to do this, how are you going to have time to come down to Miami every time when you're located somewhere else? So I thought that was a creative, an effective way to deal with this, and still didn't necessarily punish the client. I think that you have to handle it directly, have the courage to do something and not just sweep it under the rug. And I think you need to listen and see when that is actually happening. It's not always are all accusations founded.
Does anybody have any questions? In closing, anything you want to highlight before we deliberate?
Sure. Thank you for the opportunity. Thank you very much for your time. I really, really respect all you do. And I, give you a lot of credit for the judiciary we have. And as I started, I was blessed to have been, I was raised professionally in 7th Judicial Circuit, and I just had some amazing mentors and judges from the bench. And I want to be that. I want to be that for our profession. I want to be that for our community. The 7th Judicial Circuit put their effort, energy, time, and resources into me. I believe that the 7th Circuit deserves a return on that investment. And I want to do that by being a judge in the 7th Judicial Circuit. I think that I would do a great job. I would work really, really, really hard. And I would love the opportunity. So I thank you again for your time.
Thank you. Thank you.
Mhm.